I have two items of good news to share with you as I start the second part. First is that the first part today was considerably more than half of what I had to say, so we're past the halfway point. The second thing is that we're now, as we start getting into talking actually about plea bargaining, this is the part that I feel is most interesting and also most least well understood and known even in the United States. So after today's session, I am happy to sign a document for you which will attest to the fact that you hold a PhD in from the George Bisharat School of Advanced Plea Bargaining Studies, right? So anybody, if you want to draw up a document, I'll be happy to sign it at the end of the... Okay. Now, so plea bargaining, as I said, in its most general sense, is negotiations between the parties, the prosecutor and the defense, leading to the disposition or the end of a case without trial. So, I am going to discuss plea bargaining and answer the following questions. First, who is involved? Second, what is being exchanged? What are the values that each side is offering to the other? Third, when does it occur? And after that, fourth, where does it occur? After I go through answering those four questions, we'll show you the brief video clip of the plea bargaining session, and then I will make a few comments about the video, and then some final observations about why we continue to represent our system as a jury trial system when it is, in fact, the plea bargain machine. Okay, so who is involved in plea bargaining? The principal actors are the prosecutor and the defense attorney. Judges are also often involved, depending on their own personal preferences and also depending on the stage of the case. Judges tend to be less involved early and to get more involved as the case progresses closer to trial. Note that a central character, the defendant, is not directly involved in plea bargaining. It is the responsibility of the defense attorney to convey an offer of settlement to the defendant, and the defendant decides whether to accept the offer or not. But otherwise, the defendant's role in plea bargaining is passive, or absent, more accurately. Now, let's focus on each actor for a moment and draw out some underlying assumptions that rationalize their involvement in this process. So, the prosecutor can only engage in the process of plea bargaining if he or she has authority over the disposition of the case. You can't trade something that you don't have or that you don't control, right? So one of the structural foundations of plea bargaining is our strong tradition in the United States of prosecutorial discretion in charging, whether to charge a case or not, how to charge it, by what procedural means, and what particular offenses to charge, okay? There is no compulsory prosecution in the United States the way there is in some other systems. Prosecutors don't have to take a case forward if they don't want to, if they don't see the need, or they don't see the necessary evidence. Victims are not parties, in our system, are not parties to prosecution. We don't have private prosecution, again, the way some systems do. They are, they are simply witnesses in the case in which they happen to be victims. And they have no direct authority over the disposition of a case. Prosecutor in our system is a part of the executive branch, and the top prosecutor in a judicial district, we have various names for them from one jurisdiction, from one state to another. In California, they're called district attorneys. The top district attorney is an elected official. And the way we sort of think about this prosecutorial discretion is that if a prosecutor is abusing this discretion, then the check on that abuse is political. Next time this person is up for election, you vote him out of office, or her, okay? So there is no, in other words, legal or very little legal control over, by the courts, over the prosecutor. So if this were not the case, then the prosecutor wouldn't have anything to trade or to offer to the other side. But because of this tradition, the prosecutor is the one who holds greatest authority over where a case goes and what happens with it. Now let's look at the defense attorney. Formally, of course, the defense attorney is charged with representing the interests of their clients. And they join plea bargaining, they are involved in plea bargaining as proxies or representatives of the defendant. In the division of authority over a case between the lawyer and the client and the defendant, the defendant has exclusive authority over what plea to enter. It is solely the defendant's choice to plead not guilty or guilty. In practice, of course, attorneys have great power over this decision, and that power is exercised in how they present and how they position an offer for settlement to the defendant, right? And a lawyer who basically can get defendants to do what the lawyer thinks is best is often praised, especially by judges, but also by other lawyers, as exercising good client control. That's how it is termed. To be able to present an offer in such a way to the defendant so that he or she accepts it. Now, this is a very important and interesting topic. I'm not going to go into detail in this now, but in fact, attorney-client relations, you know, the attorney is supposed to solely represent the defendant. In fact, attorney-client relations are rife with tensions between the attorney and his or her personal and to some extent financial interests and the defendant's interests. Ask me about this later if you're curious. But defense attorneys, as a matter of actual practice, not the way they think about it, but in fact, perform the role of disciplining the client to accept a plea to the benefit of lawyers and the court and themselves, and to some extent to the detriment of the defendant, him or herself. Okay? Now, the way lawyers think about this themselves, defense attorneys, and I know this both because I was one and because I was around them a lot, they know better than their defendant what's really in the defendant's interest. So, you know, like the defendant doesn't want to take a plea, you're an idiot. Come on. You know, you go to trial, you're going to get slammed and you're going to be, you know, You want to go before a jury with that story? Fine. Here's what a jury's going to say. All of these techniques are ways to basically persuade the defendant to accept a plea. But as I said, the way the lawyers think of it is that this idiot, you know, he doesn't know what's going to happen at trial. I'm the one I've tried 50 jury trial cases. I've done 6 just like this, right? And all of my clients got slammed, and they all got, you know, sentenced to X number of years. So if I twist this guy's arm to accept the plea, well, in fact, it's for his benefit. That's the way lawyers rationalize this. Now, let's talk a little bit about the judge or the court. So, by law, judges have almost complete authority over sentencing, right? In our system, that's the way, where juries actually, in limited kinds of cases, for example, in death penalty cases, actually also have a role in sentencing. But in the far more typical case, jurors don't have anything to do with sentencing. In fact, it's improper to even talk about sentencing before the jury. So it's up to the court. And what this means, this invests the court with the power to approve the terms of any agreement that involves a sentence. And the court also presides over the formal process of the entry of the plea. They have very limited authority to dismiss charges. Now, it can happen in California, at least, not in all of the states, but in California, if the defense attorney and the prosecutor fail to reach an agreement, the defense attorney can negotiate directly with the court. And the court may undercut and offer a lower sentence than the prosecutor is offering. However, under these circumstances, because the court does not have the discretion whether or not to charge and what to charge, that's the prosecutor, the court can't force the prosecution to dismiss any charges. And therefore, when the defendant, the downside or the disadvantage of going to the court is that you have to plead guilty to everything that is alleged in the complaint, okay? And that is called, the expression for it in California is called pleading to the sheet of paper. You know, you plead to the sheet, or you plead open, okay? Wow, I haven't used any profanity yet. I'm getting to it. So I'm starting to get into the jargon, you know, pleading open, pleading to the sheet. This is plea bargaining jargon. I already said that, you know, sometimes judges will take a kind of a hands-off approach in the early stages of the case. They'll leave the negotiations to the two parties. But as trial looms, becomes imminent, then the interest of the court in avoiding trial and the time and expense of trial kicks in, and judges tend to get more involved, directly involved in negotiations as trial looms. Now, the defendant. So, just like a prosecutor cannot bargain away something that he or she does not possess or control, the same is true of the defendant. The capacity to enter into a bargain derives in part from the fact that we conceive of jury trial as a right. And this is actually enshrined in the federal Constitution, and this is one of the rights that has been held applicable in the way I described earlier through the 14th Amendment to all of the states. So the defendant has a right to a jury trial, and therefore can trade away this right. Constitutional rights generally in our system can be waived. I'm not talking about waving my hand. In English, the word is spelled W-A-I-V-E, and that means to give up or surrender a legal right, okay? So As to constitutional rights, under our law, these can be waived or given up if the waiver is knowing, voluntary, and intelligent. That's the phrase, the legal phrase that's used. Now, it does require a certain kind of legal fiction to imagine a criminal defendant as freely accepting a plea deal, for example, involving 5 years of prison when they would otherwise face a sentence of, let's say, 15 years. This is, you know, like bargaining with a gun to your head, with a gun to the head of the defendant, and you're free to do whatever you want. You know, boom, if you don't, right? That's the implied threat. But somehow this is just, you know, kind of legally not relevant or held to be not coercion. It's just overlooked. Okay, so that's about the actors. That answers the question, who is involved? Now, what is being exchanged? What is actually the substance of plea negotiations? So the basics are pretty simple, and you've probably already figured out what they are on your own. The prosecutor gives the defendant lesser consequences, usually meaning less time in custody, right? It is theoretically possible, and it does happen in minor cases, that the defendant can negotiate for and receive outright dismissal of the case. The case just goes away. That's almost never happens in serious cases. It's in relatively minor cases. It might be a situation in which, you know, I vandalized my neighbor's car, right? And I'm willing to pay restitution to my neighbor, and I'm willing to sign an agreement, and the neighbor says, yeah, fine, let's not proceed criminally. I'm willing to accept $350 to repair my car, and, you know, we'll just, the prosecutor will then dismiss the case. Okay, so it can, what happens as a consequence of plea bargaining can run all the way from that at the lowest level to complete dismissal with no criminal consequences whatsoever, to the kind of the ultimate is in a death penalty case in which the defendant agrees to plead guilty to a term of life without possibility of parole. So that's the range, all the way from 0 to almost, you know, just one step short of the most severe punishment, which is death. So the defendant is giving to the prosecutor and the system as a whole a savings of the costs associated with the trial, which I spent the first hour trying to impress on you, what those actual costs are, and also provides the prosecutor with the certainty of conviction. Those are really, so the prosecutor is giving lower criminal consequences, possibly none at all, and the defendant is giving back two things: the cost savings of trial and certainty of conviction. Certainty of conviction is of value to prosecutors, both because they may recognize that some criminal liability is better than none, right? And if they assess there's a chance that I could lose this case, you know, I would rather have this guy serve 2 years than none at all, right? And also because low conviction rates reveal them to be wasting community resources, and thus subjects them to possible political reprisal. So meaning they could be voted out in the next election cycle by somebody who comes along and says, this guy's getting a 60%, you know, conviction rate. That's ridiculous. We should have 75% or 90%. And, you know, this makes sense to, you know, to voters, right? What's this guy doing? you know, with charging all these idiot cases that they can't even get a conviction on. It's a complete waste of money. So that's why certainty is of value. Now, for prosecutors, it's important to understand that a guilty plea may also be just a way station or a step along the way to the longer-term incarceration of the defendant. Here's how this works. I'm the prosecutor. So defendant X comes before me. He's got a possession of cocaine for sale. Okay, that's a felony in the state of California, punishable by 3, 4, or 5 years in state prison. He's in custody. Most felony defendants in the state of California are in custody, and this is hugely important, right? The guy's desperate to get out of custody. I know that. Custody is miserable. The jails are awful. I mean, terrible places to be, right? I have a big pressure point that I can use here. Okay. He's been in custody already 45 days before preliminary hearing. I will offer you a sentence of probation. That means probation is a period of conditional liberty. After a conviction, you're released into the community, and you are allowed to remain free as long as you abide by certain terms and conditions. The most fundamental, I mean, they range tremendously, what the actual conditions are. But the most fundamental one of every probationary case is that they not violate the law again, right? They may also have to report to probation officers. They may have to, undergo drug testing, that sort of thing. Another very common thing in the state of California as a condition of probation, people surrender their rights to be free of a search. I could recite the litany to you of what we have to tell defendants, because I said it probably 10,000 times. And they trade away their rights to be free of an illegal search and seizure, right, as a condition of receiving probation. Okay, I'm going to give you this sentence, and you can get out of jail now, let's say, with credit for time served. The time that you have already served in your case, that will be all the custody you have to serve at this stage. Go on out. You're free. Out they go, and I know, because of the nature of this business, he's going to be back here in 2 weeks, 5 weeks, 7 weeks. He's going to be back, right? He's back. He's back. He's got arrested on a new case. Hey, guess what? A probation revocation hearing. One thing I didn't explain about a probationary sentence. There is always associated with probation what is called a suspended hanging sentence. And, I don't know if you're familiar with Greek mythology, but the sword of Damocles, hanging over your head, right? If you're good, it never drops. But if you misbehave, here it comes, boom, the suspended sentence comes down, off you go to prison, okay? So, now, here's what's very important to understand. With a new offense, a person is entitled to a jury trial. With a probation revocation hearing, no. You're entitled to a hearing, but it's before a judge, not a jury. The standard of proof is by a preponderance of the evidence, not beyond a reasonable doubt, which is the lowest standard in our legal system. Evidence seized in violation of the Fourth Amendment, that is the one that guards against illegal searches and seizures, can be used in a probation revocation hearing. And hearsay, which I told you about earlier, an out-of-court statement, can be used. So this is, in contrast to a jury trial, is a highly expedient procedure, right? All they need to do is bring in the police officer who arrested the guy for selling again, and in the space of 20 minutes, he's gone. right? So now there is plea bargaining that happens in association with, probation revocation hearings. There's actually a lot of litigation that involves probation revocation and not, well, it may be on the grounds of a new offense, it may be on the grounds of a violation of a non-criminal term of probation, like failing to report to your probation officer. So, but the question in plea bargaining is, here it comes, I warn you, how badly fucked is the defendant going to be in this? Is it going to be fucked really, really badly or just badly? That's kind of the nature of negotiations over probation revocation, right? So for a prosecutor, hey, I don't care. Let him go now. I'm going to get him in. I'm willing to bet $100 that within 6 months this guy is going to be in prison, right? So a plea can be a cheap way, an expedient way to get almost the same thing that you would get, if you convicted him at jury trial, but without all of the hassle, right? So, this is yet another value that prosecutors appreciate about plea negotiations. Now, notice that I haven't said anything here about justice as a value for either side. Now, perhaps I'm too cynical, but I really don't think justice is a major preoccupation of either party to these negotiations. It is possible, however, and sometimes in plea negotiations, lawyers do talk about justice. I don't want to be completely unfair. They do, now and then, right? It is possible to see plea bargaining as a means of tailoring punishment to individual circumstances and thus to serve justice. So sometimes that's the way these, that's kind of the character of the negotiations. Now, most plea bargaining starts with reference to a standard offer. Now, a standard offer is kind of the market rate for a particular kind of case. The usual thing that would be the usual kind of sentence that would be offered for a particular kind of offense. These are established in part by custom and also within prosecutors' offices by supervisorial oversight of prosecutors. So the little, young prosecutors who are in the lower courts, they sort of take orders. They get parameters from their superiors who say, hey, in this kind of case, this is kind of the range that you can do, and don't go outside these boundaries, okay? And it is considered unseemly for there to be too much variation in punishments between cases of the same offense. Justice begins to look arbitrary if Ricardo gets, 90 days and Roberto gets 180 days. Why? I mean, that shouldn't be. I mean, that suggests that it's just a matter of sort of chance, right? And therefore, we need uniformity. That's why there are standard offers. So what the attorneys actually or generally negotiate are whether there are circumstances in aggravation, meaning things about the particular case that make it sort of particularly nasty or unpleasant, or factors in mitigation, that is, that make it less than this standard, that would justify deviating from the standard one way or the other. So that's how a lot of plea bargaining goes. You start off from this kind of presumption that it's going to be a particular sentence, and then you sort of negotiate about the particular circumstances and sometimes often arrive at an agreement. Now, attorneys have an expression to know what a case is worth. And it is said admiringly or approvingly by one lawyer about another. So if I said, Fred, you know, he's a lawyer who really knows what a case is worth, I'm paying him a compliment. I'm saying, that's good. So what does this mean? What does it mean to know what a case is worth? Basically, what it requires of the attorney is to look through the case from beginning to end and to analyze what is likely to happen at each procedural stage. And these are the kinds of factors, this is a partial list, not an exhaustive list, but these are the examples of the things that lawyers take into account. Is there a motion to suppress evidence in this case on the grounds of an illegal search or seizure? If the motion were granted, will that gut the prosecution's case and force dismissal, or will it merely weaken the case? Is it you know, more or less key or central evidence, or is it peripheral? If the prosecution can still go forward, they can survive the motion, and they have other evidence that they can rely on. That's different than if they lose the most central evidence in the case. What is the defendant's criminal history? Their past experiences with law enforcement. Do they have a lot of law enforcement contact or just a little? Are there patterns in the defendant's criminal history, usually as reflected in government-maintained what we call rap sheets or printouts of criminal history? Are there patterns that could be meaningful? Is this a person whose criminal, you know, the trajectory is ascending? The offenses are getting more and more serious over time? Or is the person on on the downhill slope of their criminal career? Are there gaps in their have they been, you know, fine, they were terrible, you know, 15 years ago, but they've been clean for all of this last 15 years. That's a different situation than if the criminal history were just over the last 5 years. Does the defendant have other currently pending cases? It is not at all uncommon for somebody to have 2 or 3 active cases within one jurisdiction, right? These are busy guys. They are mostly guys, by the way. I'd say probably 85 to 90% of criminal defendants are men, right? They're active, you know, they have lives, and their lives involve regular violations of criminal law, and sometimes they get snapped up 2 or 3 cases at a time, right? And just like if you go to, I don't know if you probably don't have Walmart here, but this Walmart is a store. Do you have Walmart? Okay. If you go to Walmart and you buy, you know, 15 mangoes, you pay less than if you were buying a single mango, right? Same volume discount in the criminal justice system, right? You have 3 cases, it's much better than having, you know, than negotiating them all serially. You package them up and offer them to the prosecutor as a package deal. Does the defendant, here's another kind of consideration, does the defendant have prior convictions that can be used against him at trial in one way or another, making it risky for him to testify? I didn't have time to go into this much. I skipped over this business about the impact of priors on trials, but there are various ways in which prior convictions can be used against a defendant despite the general ban, which I did mention, of character evidence. Then, yet another is, how sympathetic is the victim in this case, if there is one? Tremendously sympathetic, or is the victim just as big a jackass as the defendant? That can happen, right? You can have mutual, you can have a fight, for example, and the victim witness may be an absolute jerk and will come off that way to a jury. Okay, that's a different case than somebody who's, you know, a demure, you know, 60-year-old Asian woman, you know? Or is the victim a flake who may not appear in court or will go sideways on the stand? To go sideways, the stand means the witness stand, where the witness sits when they testify, and to go sideways means to suddenly start saying things completely different than what they've already said to the police. That happens in jury trials. And it's completely unpredictable, right? Well, it's not, actually, my point is that it's not completely unpredictable. It can be predictable. You can see it in some people, in some witnesses. Or maybe you've seen it already at the preliminary hearing, how they flaked and how they went sideways, right? If there are only police witnesses, are there personnel records that can be sought that might show past instances of police misconduct that you can use against the policeman at trial? Are the particular facts of the offense ugly? Robbery in our law is the taking of anything of value from the person of another through the use of force or fear. Force or fear, right? So you can have a robbery offense that involves only fear, where some, you know, 6'8" you know, defendant comes up and says, "Can I have some change?" You know, and that's a relatively, I mean, it might be charged as a robbery. And you can have a case in which a guy comes up with a gun and pistol whips somebody and takes their money. They're both robberies, but they're very different kinds of facts, right? So how the specific facts of how the offense was committed matter. Likewise, you know, you compare, you know, two people are charged with shoplifting. One is charged with stealing a $7 bottle of vodka, and the other one is charged, happens to be one of the few women in the system, with stealing baby diapers. Very different kinds of facts, same offense, one more aggravated than the other. Is there a plausible defense in the case, particularly one that the prosecutor can see from the evidence that's available to the prosecutor? Is the defendant a veteran? We have a veteran. A veteran means somebody who has served in the U.S. Armed Services. There's a veteran discount in plea bargaining. If you served in the armed forces, it doesn't, you know, could be the same offense somebody else committed, but you get special treatment. Just like they get to board the plane first these days, they also get a discount in plea bargaining. There are many other idiosyncratic and human factors that influence what a case is worth. How competent is the trial attorney, how competent at trial, you know, how good a trial attorney is opposing counsel? And is that person, does that person have the guts to go to trial? I told you about how, you know, trial is a high stakes, sort of a high wire act. And it's hard for lawyers, and a lot of lawyers are afraid of going to trial. They're supposed to be, their career is supposed to be that of being trial attorneys, but they don't like to try cases because it's scary. We all suffer a certain degree of performance anxiety, and for some of us, it's greater than others. And if you know that, you know, Fred, he's scared to go to trial, I'm going to just drive him into the floor in our negotiations, and he's going to give me what I want because he doesn't want to go to trial. Or, and I know this will sound crazy, I've been talking with Fred. I know he likes golf. He's been talking for 6 weeks about how he's going to go to Scotland on a golfing tour. These are all real examples, real examples. And it's 2 weeks before his vacation. He's not going to try this case. I know he's not going to try this case. Let's not kid ourselves. You're going to Scotland. You're not going to cancel your trip for some freaking defendant. Come on. So Fred's going to give me exactly what I want, right? And there are many I guess one thing that these sort of examples make clear is that the people who are engaged in these negotiations are almost always repeat players. They know each other very well, right? I know this guy because I deal with him like 3 times a week. I'm in court with him, right? I know everything about him. And I know everything about his family life and all that stuff. We spend a lot of time together. And so I know he's going on this golfing vacation. There are lots of other things like this. If you're so lucky as to have your case come up to hit calendar in the week between Christmas and New Year's, hey, this is party time. Everybody at the Hall of Justice, nobody wants to try a case in that week. That's crazy. No, you're adjourning court at noon and having parties and drinking wine and having a lot of fun. So, and plus, this is the season of generosity. So, your defendant ends up on calendar in that week. It's like a gold mine, right? Or like a Christmas gift. Okay. You might have one day a visiting judge from out of county. Typical of visiting judges, they're scared. They're not going to rock the boat. They're not going to do anything unusual. So that's not the day to plea bargain your case, right? You're going to wait until Judge X comes back. And Judge X, I know, again, because I spent lots and lots of times with Judge X. Here, I'll name him, Judge Moscone, right? I spent lots of time in the courtroom with Judge Moscone. I happen to know that Judge Moscone is a gun nut. He likes guns. He's the only judge in the whole Hall of Justice in San Francisco who likes guns. So if I have a gun case, possession of an illegal weapon or something like that, I want to be in front of Judge Moscone. And we do have some limited powers to steer cases one way or another. It's limited, right? We're not really the judges themselves are in control of where cases go, but we can finagle a little bit, and we can steer cases a little bit to where we need them to go. So I could go on. There are plenty of factors like this. Now, I want you to note 2 things about these factors. Again, they demonstrate how jury trial and plea bargaining are linked. Okay, think about it. Like I said, knowing what a case is worth is basically a predictive process of analyzing the case and determining what would happen if this case went to jury trial, went all the way to jury trial, and of course at every stage along the way. And so, it takes a lot of experience dealing with lots of different kinds of cases in order to develop that predictive judgment, okay? So that's one way in which it's linked. And then I've also mentioned how, if you're a good trial attorney, you can extract concessions from the other side. So it's not like the two are not unrelated. They're very integrally related. The other thing I want you to note is that all of these things that I've been referring to pretty much relate to the 2 basic things that the defendant can offer in plea bargaining. They're all variations on the questions, how much court time can I take up? For example, with pretrial litigation and with a lengthy trial. In other words, how much pain and how much expense and cost can I inflict on the system? And that determines how much I can save it. That's what establishes the value, right? If I have a case that has a motion to strike a prior, which I explained earlier, a motion to suppress evidence, and in which I see that there's, I can do yet another motion to discover the records of the police misconduct, and I actually get some records of the misconduct, and I might be able to find the witnesses who would come in and testify to that. All of those things invest that case with greater value than a case that doesn't have any of those. The other question that it relates to is, how much uncertainty is there concerning the conviction? The more uncertainty, the more there is to give the prosecution in accepting the plea, the certainty of conviction, right? If they're not sure that they could try this case and come out with a guilty verdict, they're much more likely to, you know, because let's say there is a looming defense. They can see from the police report, there may be some issue here, let's say of self-defense in an assault case, right? They can see it from the police report. They're going to, okay, right, so that's different than in a case in which it looks like the facts are very straightforward. Okay. Now, when does plea bargaining occur? I'm going to go through this quickly. Plea bargaining happens at any point in the case. In fact, it is technically possible for it to happen even before a case is filed. But it starts then and it goes all the way up until into trial. You can have plea negotiations going on after the trial has already started. So in other words, it is a process, plea bargaining is a process that unfolds over time. It's not well, it can be, you know, you can reach a quick agreement, but far more commonly you have stages of plea negotiations that unfold over the procedural history. Every time that case is in court is a potential opportunity for the case to be negotiated. There are particular moments in a case that are ripe for settlement, and this is principally where either some resources are going to have to be expended, and thus, you know, if you plea, you can save that expense, right? Or where there are elements of uncertainty that arise, right? So, for example, and it can and often is both, right? So I have a motion to suppress evidence in my case because I think that the police have done an illegal search. The prosecutor, this is the moment where that prosecutor's anxiety is heightened because, hey, what if I am granted this motion, their case is going to get weaker and may even go away entirely, right? So right before that motion is a particularly ripe time for settlement because Fred's scared. He's going to lose the hearing, right? And the evidence is going to go away. So I say, Fred, what do you think? Should we settle this case? We won't have to go through, you know, this hour-and-a-half hearing, and you'll get your conviction. But in order for me to convince my client to accept this plea, you have to give me X. And Fred will think about it at least far more sympathetically than at other moments in the case. Okay, very close to the end. Or at least not to the end, but to the showing of the video clip. So where does plea bargaining occur? Now, you may think that this is an odd or irrelevant question, but in fact, it is very important. Typically, plea bargaining occurs in the judge's chambers. That is his private offices or her private offices behind the courtroom somewhere. The key thing, however, is that it almost always occurs in private, outside of public hearing. Now, it may be, plea negotiations, you know, sometimes occur in the hallways, in public spaces where the attorneys can be seen, but their actual negotiations are not overheard. They take pains to make sure that nobody else is overhearing their negotiations. And crucially, these negotiations happen outside of the presence of the defendant. Why this secrecy? Why are plea negotiations conducted in secrecy? Well, there is a strong perception from all parties, you know, prosecutors, defense attorneys, and the court, that secrecy or privacy is necessary to successful negotiations. And by successful, I mean at this point simply negotiations that actually lead to agreement. Okay, I'm not saying, something can be successful from the defendant's standpoint or not, All I'm saying is that we actually do reach a deal. Secrecy is necessary because both sides may need the freedom to say or do things that they suspect that either the public or the defendant may not approve. So just an example, a defense lawyer may distance himself from his client, saying, this guy is a fucking asshole, and he's totally unreasonable. I know, I'm really sorry, he's just a fuckhead, and he will not, do anything that I say. I will do my best to convince him to take this plea, but you better give me something so that I can get him to take a plea, right? And this positioning can be tactical. In other words, the defendant may not really think, that his client is such a fuckhead, or he may actually be speaking sincerely. And either of those are a possibility, and you can imagine that a defendant wouldn't appreciate being described in those terms to opposing counsel. Or it could be a judge observing how weak a particular prosecution witness is. And this is generally, a judge might do this in order to put pressure on a prosecutor to lower an offer. And it could be that fucking, person, victim, she is just ridiculous. And I sure as hell wouldn't want to try the case with that, with that fucking bitch. This is the way judges talk. And needless to say, that is also not behavior that, is particularly flattering and, is possible to be conducted in public. But it is effective in helping to propel a case forward to a disposition. It is also necessary, the privacy thing is necessary because of, I will outright call this the ethically suspect practice of trade-offs between multiple cases. So in many plea bargaining sessions, lots of cases are discussed. And, if I'm a public defender and there are certain ways in which calendars get organized so that most of my cases at a particular stage are going to occur on one day. So I don't have to go to court every, this court, that court, all over the place. They're kind of concentrated on one day in one courtroom, right? And I may have 8 cases set for preliminary hearing on that morning, and we're negotiating not about one case, but about 8 cases, okay? And now this tends to happen not explicitly, but tacitly. In other words, it's not acknowledged, but it basically amounts to, I will give you X on this case if you give me Y on the other case, you can only drive one hard bargain a morning, right? And I'm like, okay, you have to pick which case you're going to do that for, right? So one of your clients benefits and the others pay the price. How would you like to be the defendant who's paying the price? Hey, that other fucker got, this, and I'm fucking getting this. Why? You fucking sold me out, right? And that is, in fact, what happens. There are these trade-offs between cases. You can't do that publicly, right? So this is another reason why secrecy is necessary. Okay, we are ready to run the video. And Mariana? Okay, you've delegated it to, good. Okay, so I'll just, as they're...
Hi, Kate.
Oh, hey, George.
How are you?
Nice to see you.
Good to see you, too.
Can you stop, just pause it for a sec?
Thank you. How are things?
Can you pause it for a second?
Yeah, not bad. Not bad. Busy.
Pause. Pause the, thank you. So let me just say, this is an enactment, not a real case. And that's me, of course. This is my colleague from Hastings College of the Law. Roberto mentioned to you that I teach this criminal practice clinic, which is a course in which students are actually working in the courts. They're certified by the State Bar of California so that they can actually represent cases, real cases. And we use this as a kind of a training film to help them understand plea bargaining. So those are the circumstances of this particular event. And the case involves a driving under the influence of alcohol charge. Okay?
Hi, Kate.
Oh, hey, George.
How are you?
Nice to see you.
Good to see you, too.
I'm well. Have a seat. Make yourself comfortable.
Thank you. How are things?
Good. How about for you?
Yeah, not bad. Not bad. Busy. Got 2 cases on the trial calendar next Monday. So I'm busy writing in limine motions and that sort of thing. Getting ready for trial.
It's always nice to see written in limines.
Yeah,
I'm a fan of those.
Well, no, I always do those. I know not everybody does, but I want to make sure I've got the right file here.
I have a case here. It says Gerald Nobier is the defendant.
Right, yeah. Well, you know, I don't know what you think, but I think we're going to have a difficult time resolving this case. Here's the deal. I don't think my client was driving this car. And I would have a very hard time pleading him to anything that would involve driving as an element of the offense. And I realize that doesn't leave us with a lot of options.
No, it doesn't.
But I mean, you know, honestly, ethically,
yeah,
it would be very hard for me to recommend that this guy take anything that involves driving, even a dry reckless, you know. And I understand with this record, you're going to be wanting something, you know, more than that. But I think it's going to be tough.
Well, George, I can understand your concerns in this case, and I share some of them with respect to the strength of the case generally.
Right.
I wouldn't be proceeding if I didn't think your client was the driver. Obviously, if he were not the driver, we wouldn't be here, at least in my view.
Right.
That said, I do understand this difficulty with the case, and you've already had one of the priors stricken. Here we are. It was originally 3, and it was a felony, and now we're at 2. But I do think, given the results of the motion to suppress, that the keys will be available. Given the ambiguity about the Miranda issue and whether the statement, his actual statement, is going to come in, I think a jury is likely to convict.
Let me point out, of course, with respect to the statement, that statement is more exculpatory than it is inculpatory.
Am I reading left?
He's asking if there was somebody else arrested at the scene.
Yeah, let's
So,
see. Is that the only statement we've got?
Well,
yeah.
That's the way I recall. He said that he'd bumped into the curb.
Yeah, now I realize that could be construed as if not he was driving, but that maybe he was drunk and he bumped into the curb, what happened.
Yeah.
Or that the car did and he just, you know, the police officer got that part wrong.
Yeah.
I do realize that there's some ambiguity there.
Right.
And again, I agree with you. This is certainly not a case in which I think jurors are going to come to a decision readily, and I think it's going to be challenging. But as I look at it sort of in terms of my job is to seek justice, and I believe your client was the driver and is responsible for this DUI, along with the 2 priors that are charged. I also think that there's a public safety issue here. Your client appears to have, you know, a substance abuse problem with alcohol.
Well, yeah. I mean, he did. He had a stretch in his life, you know, some years back, when he had a lot of trouble with romance and finances, you know, the typical stuff. And he went through a rough period where he picked up the priors. But they're all bunched together, and then he goes for a long period where he's employed, he's doing a whole lot better. And then there's this, and then of course, you know, obviously if you think this is a continuation of, you know, past behavior, I can understand why that's alarming. But the evidence of his having an ongoing problem is not really borne out by the record of the priors.
That's a legitimate issue, in the sense that it does appear to be a sort of a period in which he gathered. But here he is engaged in the behavior is the drinking, presumably, and the driving together. So the question is this the beginning of another period in his life where he is, again, drinking and driving?
Right.
And I don't know if this is like the first of a series, or all I know is that it's here.
Yeah. I mean, the problem is, I think you've got two major problems of proof, or two distinguishable problems of proof. One of them is that you don't have direct evidence of his driving the car at all. I mean, he may not have been driving this car at all, and you don't have, other than sort of fragmentary evidence, all of which is consistent with reasonable inferences that point toward innocence, not just guilt, but innocence.
And you're a good lawyer, and I know you'll point everyone out.
I will. That's your job. Hang on that circumstantial evidence instruction, of course. The other thing is that even if he drove the car, you don't have the nexus of the driving and the drinking. There is some elapse of time, and we don't really know how much it is because we can't pin down the exact time of the accident, and therefore it is at least possible in principle. And again, not an unreasonable inference that the accident could have occurred. He could have gone into that nearby bar. There's a bar right there very close to where the accident occurred, and he could have had a drink after the accident. In fact, it would not be an uncommon reaction to somebody who shook up from an accident, maybe in a little bit of pain, obviously nerves jangled. Maybe then he had the drink. So
that's possible, George.
And I'm not sure where in your case the evidence is going to come that's going to foreclose either of those two reasonable alternative, innocent explanations of what happened.
Well, George, I think those are legitimate points that you're making. On the other hand, as is often the case for prosecutors when we have a circumstantial evidence situation, we're looking at the accumulation of the evidence altogether.
Sure.
Your client is the registered owner of the car. He has the keys in his pocket. He has blood on his arm, which is apparently arguably consistent with blood on the steering wheel.
Right.
It's a solo vehicle accident.
Right.
He is intoxicated. It's after 2 in the morning, and while sometimes places do stay open, this is sometime after 2, we think closer to 2:45 or so.
Yeah.
It's not clear there's a place that he could actually go into and have a drink afterwards. And, there's some ambiguity about the statements and sort of whether they'll come in and which ones might come in and those sorts of things. But some jurors could see his statements as both some exculpatory but some incriminatory.
Yeah.
And there's nobody else there, and nobody apparently has seen anyone else there. At least we have no evidence of that.
Well, and why don't we have any evidence?
The officer asked whether anybody was a little late by the time the officer gets around to asking, but on the other hand, he's by himself, the officer. It's not a perfect case, George, and both issues you raise are ones I think you will point out and the jury will see.
Yeah.
It's not clear to me, given even a beyond a reasonable doubt standard, that a jury couldn't very reasonably come to the conclusion that in totality on the circumstantial evidence, that he was in fact the driver and that he was drunk, going the wrong way down a one-way street, all that, all that.
Of course. And if you didn't believe that, we wouldn't be talking about this.
So, do you want to make the first referee? Would you like me to?
You're
talking about a dry reckless. I'm not there. Maybe, and then you might not even be able to persuade your client to take a dry reckless.
Earlier I said that I wouldn't. I would have a difficult time encouraging my client to take any plea that involves driving as an element of the offense, and that's because I don't believe he was driving the car. However, I would put it this way to him: if you were to offer a dry reckless, I would figure out a way. I wouldn't stipulate to the in the entry of the plea. I wouldn't stipulate to a factual basis, but I would stipulate to the court's reading of the police report and using that as a factual basis. So I won't be involved in put my professional reputation behind a plea that I don't believe sticks. But I wouldn't bar my client from entering such a plea. And furthermore, I would counsel him frankly about the odds and allow him to make his decision. And he may very well. Most rational defendants would probably accept a dry reckless. So, I'm not going to push him. I'll lay it out straight for him, and he can make up his mind. But dry reckless is really about as far as I could go.
I understand you want a non-priorable offense, and I understand the position you're in, believing that he was not driving. All that said, I don't think we're in the same place in terms of where we are about settling this case. Consequently, this is where I'm at, I'll share with you, and there's still, I think, a wide gap.
Sure.
Given the circumstances as we are in San Francisco, it is not the strongest case. I would offer him the current offense, which is 1 count of the DUI and the allegation of refusal. I would drop the other 2 charges, the priors, and it would be as if it were his first offense.
Yeah.
It's still a driving offense. It's a priorable. It's obviously not something you're going to counsel your client to take.
Right.
I understand that. Given that, I think we should anticipate that there will be a trial in this case. And unless circumstances change, and if they do, we can have another conversation,
Sure.
obviously.
Yeah.
But absent that, it sounds like we're not going to reach a
Well,
resolution.
I wish I could tell you that I thought you were being unreasonable. I don't. I understand your position too. And under normal circumstances, in a case that had a little bit more, that had tighter joints, or I would consider that offer generous, and I would certainly counsel my client to accept it. On these facts, as you know, I don't think I can. I obviously have an ethical obligation to convey the offer that you've made to my client, and I will certainly do that. And yes, you're right. I think I really my other ethical obligation is to give counsel to my client, and my counsel will be for him not to accept the offer and to take the case to trial if necessary. And then, if we come back on trial date, or I guess we don't really have any other. We'll just be back for motions in limine and trial, and maybe some of the rulings on the motions in limine, will influence things. Yeah,
right. Either
yeah.
of us.
I mean, I will certainly be making a Bracamonte motion,
of course,
and, a motion to exclude the priors for impeachment, which I expect in this. I mean, the Bracamonte motion is granted in this county on a as a routine matter. Most judges, I think, will probably also exclude the priors for impeachment.
Unless your client were to testify and open the door. I think that's
right.
True.
Yeah, if he says specific things that open the door, yes, I agree. But in the absence of that, I think they would be excluded. So, his testifying is not barred by priors in the way that is often the case in many.
But
in many other
given
cases.
this, obviously, given the facts as we both see them, at least what we have in the police report, it could be that your client exercises his Fifth Amendment right and doesn't testify at all, and you rest on. But it also could be that he testifies, and that also could alter how the jury perceives this case if he does.
Yeah.
So,
well, I mean, you can assume that I won't put him up unless he won't choose to exercise his right to testify, I should say, without without my having. Made a judgment that's going to be helpful.
But it's his right.
It is his right. Yeah, he can make up his own mind and take his own chances.
Right. But I agree with you. Let's see how things proceed in terms of motions in limine. But at this point, I think we should assume that it's going to go to trial.
Okay.
And,
well, I tell you what, I will keep my offer open if a dry ride.
Thanks, George.
Yeah.
And you know what? As a courtesy, I will keep my offer open as the current offense with the allegation of refusal.
Good.
Until we start the immunities.
Yeah. Okay. Sounds good. All righty. Thanks a lot.
Very much,
we'll talk
George.
to you soon.
I appreciate it.
All right. See you.
Bye-bye.
Bye-bye.
Okay. Anna, are you able to hear me? Okay. Sorry for the technical problems and the resulting delay. I'll make a few comments about this video, and then just a last few concluding words about why we continue to represent our system as a jury trial system, despite the reality. So I'm going to say a few things about what was typical about this demonstration and what was not typical. So what is not typical? First, well, no profanity. You didn't hear any profanity. My colleague, delightful woman, I love her to death, probably the most proper person I've ever met in my life. It would melt her soul to hear what I would have normally said in a plea bargaining session, so I spared her that pain, right? So that's one sense in which it was atypical. The duration of this negotiation, unusually long, although perhaps not so for the stage at which the case stands here. We've gone through a lot of pretrial litigation. You've heard references to different motions. A motion to strike a prior, which was successful. They almost never are, but in our case, it happened. We had a motion to suppress evidence. You heard that referred to. That was unsuccessful. So we've already, you know, there's nothing left before trial, right? So at that stage, it's not unusual to have a negotiation that could go on for this long. The typical one would be at an earlier stage in the case, would be like this. And if you want to start your timing device, I'm willing to bet it's under 30 seconds. Okay, you know, people versus X. ISS 3 CTS, APD, 1035 search condition, 100 VIF, 90 days CJ. No, I don't think my client will take that. How long was that? That's the typical. That's the typical. That is the entirety of a plea bargaining session at an early stage in the case, where the prosecution gives an offer to the defense and the defense says no thanks. Okay, so another thing that was not typical is that in this demonstration we didn't use a lot of jargon, the way I just did a moment ago when I gave you that ISS 3 CTS, all that stuff. None of that makes any sense to you at all, right? Most plea bargaining occurs in this impenetrable jargon. Okay? You can only know it if you have been immersed in the system and you've learned the special language of plea bargaining. Okay? You heard us refer in this to a dry reckless. There are lots of sort of nicknames or unofficial ways that we refer to an offense. A dry reckless is a reckless driving without alcohol, dry. And then there's a wet reckless, reckless driving with alcohol. And then there's a, you know, and these are lesser offenses than a driving under the influence charge. So we're kind of talking about the ladder of offenses that could be sort of related and which might be potential places at which we could come to agreement, all right? But we wanted this to be understandable to students who haven't yet spent a lot of time in the system, so we deliberately used less jargon than usual. The third thing is the location. Now, this is supposed to be the prosecutor's office. It's me walking into her office, right? Not an unusual place. Again, as you're approaching trial, this is a plausible scenario. But it is far more typical that, as I told you when we talked about where it occurs and when it occurs at court dates when the case actually appears on the court calendar and in the courthouse in some private space, the judge's chambers, etc. A fourth thing that is a little bit atypical here is my negotiating tactic, which is pretty aggressive. It was friendly, but aggressive in this sense. I was kind of turning the power tables on the prosecutor here. Partly, I come in and I'm the one who starts. I'm the one who starts the discussion. And I'm basically saying, I don't think we're going to reach an agreement. From the beginning, I'm saying, nah, we're not going to reach an agreement. This case is going to trial. That's basically an implied threat, right? You're going to have to try this case against me. And that's what's going on from the very beginning of this negotiation. And typically, the prosecutor is much more powerful than the defense attorney. I am able to do this in part because, in this case, in part because of the particular facts. I'm in a little bit stronger position than I usually am in a defense case, so I can afford to take a kind of a hard line with the prosecutor. And I end with this sort of flourish, which is like a little needle prick to her, saying, in my magnanimous self, I'm going to keep my offer open for you. I'm not going to withdraw it. This is usually what prosecutors say to defense attorneys. And it's a way of expressing power by saying, oh, you know, I'm the bigger, more powerful one here, and, in my beneficence to you, I'm going to not force you to kneel down and take your punishment now. You can have it later. Okay? So I've taken this phrase, which prosecutors always say to defense attorneys, and I've said it to her. I'm being the big one here, right? I will keep my offer open for you. So that's atypical. Some things that are typical and that may surprise you a little bit, the friendliness of this exchange. It's not a very heated exchange. Now, generally speaking, when you're in the Hall of Justice and this is your regular, you get to know these people, as I've said before, you get to know opposing counsel inside out. Now, when you're little cub, baby fledgling attorneys, you're at each other's throats. And it's because you don't really have experience. There's much more anxiety and fear on the part of the opposing party. So if you looked at a negotiation between two young attorneys, inexperienced attorneys, then it can be much more aggressive, overtly aggressive, right? But between experienced attorneys, people who know each other well, this kind of friendliness is typical, actually. We get along fine. I like Kate. She's a prosecutor, so there's only so far our friendship can go. But I respect her. I know she's smart. She's a good attorney. It's not about us personally. Okay. The basic substance of the exchange. If you think about what's going on here, if you could understand, what I was saying. Basically, what I was trying to do was press her buttons to remind her of the weaknesses in her case, and to talk about where her evidence is weak and how she's going to have a hard time covering those things. I'm trying to heighten her anxiety and make her fear the possibility that we'll go to trial and she'll lose. Okay, so that's my negotiating strategy, is to try to make her feel like, wow, this case could go the other way. It can get out of my hands. Another thing that's typical here. Now, I have said a lot of things that are kind of disparaging of defense attorneys and that kind of reveal them as scheming fraudsters, who trick and coerce their clients into pleading guilty. That is true. It is also true that there are attorneys who have integrity. And integrity actually a combination of integrity and trial skills are actually extremely powerful weapons in the arsenal of a defense attorney, and really in a prosecutor too. I'm saying to her, to my colleague, I don't believe my client was driving. Now, if she knows me because of our past experience and that I blow a lot of smoke, in other words, I'm not truthful, then that won't mean much to her, right? I can blow all the smoke I want and she'll just ignore it. But if she's talking to me, and we've tried cases before, she knows that I'm a straight shooter and that I'm honest and that I have integrity, she's going to listen to me when I say, I don't believe my client was driving, okay? I'm putting my integrity behind the case, in a sense. And this is typical. I mean, this is the way lawyers use their personal reputation to the benefit of their clients. You heard a lot of discussion of priors. That is also typical. There's almost no felony case that gets to trial that involves a first-time offender. That just almost never happens. Partly because more attractive dispositions are offered to first-time offenders, so they tend to plead out. They tend to accept deals. So cases that reach this stage almost always involve prior convictions. And you heard me trying to argue the pattern. Remember, I told you how the pattern of convictions can make a difference in plea bargaining. And I talked about how he had these 3 convictions in the past, and then he had a long gap with no criminality. And I tried to offer an explanation for why he had those 3 convictions in succession. He was going through a personal crisis in his life. And the point that I'm trying to drive home with the prosecutor, in case it wasn't clear the first time around, is you don't have as much to fear from this guy as you would if those 3 priors had occurred in the last 2 years. You're looking at somebody who may not be as threatening to the community as you think. So I'm trying to calm her fears about that aspect, because, you know, a prosecutor's worst fear, right, in a case like this is they let the person out on, you know, on a relatively minor deal, and then 2 weeks later, he's drunk again and he runs over some young girl in a crosswalk and kills her, right? That's the prosecutor's nightmare, that they've gone easy on this guy, and there he goes out and he, you know, causes this tremendous harm. So if I can address her fears about that, then I'm that much closer to where I need to be. Okay, I think that's all I will say. Perhaps you will have other questions about the plea bargaining tape. Now I'm going to just wrap up quickly with a few observations about why a system that functions as the plea bargain machine continues to characterize itself as a jury trial system. Well, first, I have to admit that there's a sense in which this is not wrong to continue to represent it as a jury trial system, in the sense that plea bargaining is a production of and is the flip side of the jury trial system. We may not have plea bargaining if we did not have jury trials in the form that they have assumed in our contemporary legal system. So there's, in other words, a sense in which the claim that this is a jury trial system is still valid, perhaps not complete. Beyond that, however, I think it boils down to a question of legitimation. That is, how lawyers and the legal system presents itself and invests itself with authority in the face of particular audiences. And the relevant audiences, I think, here are perhaps 3. So, first of all, it is to the non-lawyer lay public in the United States itself. It's the people who are not part of the legal system. The second audience is defendants. And the third is, in a sense, all of us in the United States, all of us, and in our dealings with the global community. And I will explain each of these briefly. So it is, as a general thing, with respect to all 3 of these audiences, it is far more ennobling of the legal profession and the legal system to think of it as resolving great issues and, you know, vital criminal prosecutions by these dramatic courtroom battles in which, you know, intellectual and oratorical skills are matched against each other in this clash. Doubtless, this is why popular culture so commonly refers to trial, jury trial. You don't see television shows and movies that depict plea bargaining. What you see are shows that depict trial. Compare this for a moment to the image of the, you know, you've got this dramatic, heroic courtroom battle going on. Compare this to the reality of plea bargaining which can almost, in a sense, seem at times to reduce defendants to the status of cucumbers. It's like a marketplace, and you're bargaining just like you would bargain over fruit in the market. That's not a very pretty picture. Now, the legal profession, of course, has to convince, I mean, part of its professional project or responsibility is to convince the general public of its mastery of a specific form of expertise. That is what we sell. If we do not have knowledge that is distinct from that of others, why should anybody pay us for anything, right? So we have to mark off our expertise and distinguish it from other forms of expertise. And so mastery of a jury trial skills is much more distinct from everyday lay knowledge than bargaining skill. If you really wanted to be represented well in bargaining, you might go to a rug merchant, not a lawyer, right? They're better at negotiating than we are. Now, not quite, because we've discussed how there's a relationship between legal knowledge and the ability to negotiate effectively. So but from the standpoint of the lay public, you know, anybody can walk into the back room and negotiate possibly better than the lawyer. So trial skills are what differentiate the legal profession from other forms of expertise. Now, so that's in facing the non-lawyer lay public within the United States, that audience. So with respect to defendants as an audience before which we need to legitimate ourselves, this is perilous because, as I said, the vast majority of defendants' cases do not go to trial. But it is still important, I think, for them to see it as a possibility, them meaning defendants, and to see a plea outcome or to see a plea, a guilty plea, as an outcome influenced by trial realities, as opposed to being a product of negotiation. Now, as to the last audience, which is sort of a combination of all of us, people in the United States, and the global community. So the global community's admiration and emulation of the American legal system is a source of great pride. And of course, the export of American legal forms is a major business, actual business. And it also is, you know, so we're talking about kind of what we get from the global community, and reflected, for example, in the many visitors I have hosted myself personally to San Francisco from China, from, you know, Eastern European countries when after, you know, the fall of the Soviet Union and all of the newly independent former Soviet bloc nations, you know, they all sent legal delegations to the United States, right? We don't go there, of course, to see what they do. They always come to see what we do. And then, of course, that, you know, our reflection, the reflection back to us of what we see in how the global community responds to us is, in fact, I think, one of the fundaments of American exceptionalism. The belief that we are a uniquely endowed country, that we are special, we are exceptional, and we may claim prerogatives that others can't in the international community. That explains why a nation like mine can think of itself as a nation of laws and nonetheless hold such contempt for international law. We can zap people from the sky, you know, all over the world with our drones, right? Nobody else can do that. Or, well, Israel can do that, but nobody other than the United States and Israel. The simple fact is that we think that our laws are superior to anyone's. Nobody is going to tell us how, you know, that this is a violation. Fuck international law. What's international law? Now, obviously, this is not the perspective of every American, right? Every person in the United States. But this is a perspective, and it's held quite strongly and quite openly by many powerful people. You know, our former president, and perhaps to some extent our current president, right? We can do things nobody else can do. It may seem to you a stretch, I don't know if this seems plausible to you or not, that there is this relationship between how we conduct ourselves in the international community and our, you know, jury trial system. I personally believe that this is actually at the core of, this is one of the principal reasons why we think we're so fantastic and therefore can do whatever we want. Now, for better or for worse, I see no indication from within the legal profession or outside of it, none whatsoever, to question the plea bargain machine. So I fully expect that this plea bargain machine will rumble on indefinitely into the future. Thank you.